senator from Utah. I'm happy to comply with the 7-minute rule. Thank you, Mr. Comey, for being here with us today. Thanks for all you do to keep us safe. There's been some discussion, a little bit of confusion lately about the USA Freedom Act. In part, this has been precipitated by some of the discussions going along with the presidential election cycle that's in full tilt now. But to clarify, I have just a few questions about the USA Freedom Act and how it operates. First of all, the USA Freedom Act doesn't prohibit the government from gaining access to telephone metadata, correct?
Correct.
It allows the government to get metadata, telephone records, connected to any terrorist investigation, such that if the government wants to gather metadata connected to a particular phone number that it believes is connected to a terrorist investigation, the government can get that.
Correct.
And the USA Freedom Act does not affect in any way the government's ability to gain access to any metadata that either originated as to a phone call that either originated outside the United States or that originated here and was directed outside the United States.
Correct.
Did the enactment of the USA Freedom Act substantially affect the government's ability to prevent the San Bernardino attack?
I'm only hesitating because I don't want to talk about particular techniques we were using to understand that attack. And so I guess, Senator, I need not to talk about it in the context of that particular case.
I would note here only that it is significant that only 4 days prior to the attack, the government had access to all of the records that it had access to, for years prior to the passage of the USA Freedom Act, because there was a 6-month moratorium between its passage and it kicking in. And I personally consider that highly unlikely. Some would say mathematically impossible that it had any difference there. And certainly the government can still investigate the San Bernardino attack by going after records of the individuals suspected to be involved in that attack.
Sure.
Thank you. I want to talk a little bit about this encryption issue. I was pleased to hear you say, and I hope I understood you correctly, you're not pushing for legislation that would mandate tech companies to put a backdoor, to develop a backdoor and make that available.
Correct.
What you were saying, as I understand it, is that some companies, many companies, could choose voluntarily to assist law enforcement in the execution of a warrant in helping gain access to any information that they might have access to.
Correct. And those are the conversations we've been having.
But I assume in order to do that, would they have to develop their own backdoor that they could use internally?
Well, I don't know what, in that context, the term backdoor means. They'd have to figure out how, consistent with their security requirements, they could comply with the judge's order, as a lot of companies do today. So they'd have to figure out under our system what would be the best way to comply with the judge's order. Okay.
Let's suppose that we have companies doing that. Perhaps some, perhaps all. Perhaps they're doing it because they want to do it, or perhaps at some point, assuming Congress were to pass something requiring them to develop a backdoor, a universal key that could be used to unlock the encryption. If U.S. technology companies started doing that, perhaps some of them, perhaps most, perhaps all, that wouldn't necessarily end the going dark problem, would it? Because wouldn't we still have technology companies located outside the United States still manufacturing devices that wouldn't be subject to that requirement, or wouldn't be subject to the same thing that would be convincing American companies to do that?
No, I think that's right. Both in two respects. Devices manufactured in other places might be different, and communication services from providers outside the United States might be different, which is what makes this such a hard problem. A big piece of it has to be international.
Right. And so even assuming Congress were to enact something requiring the use of a backdoor, the availability of a backdoor, a de-encryption key, if you will, it still would not solve the problem because there'd be foreign manufacturers. It also occurs to me that even assuming all U.S.-produced devices had a backdoor key of sorts, it's my understanding that it's still possible to design an app, that there are people all over this country and in other places throughout the world who can with relative ease, design an application to be used on a smartphone, for instance, or perhaps on a computer that could provide encryption that couldn't be unlocked through an encryption key made by the manufacturer for the device in question. Is that your understanding?
My understanding is, I think the same, that with respect to a device, if the manufacturer were able to, as they were a year ago, to unlock on a judge's order the device, there may still be apps on the phone that are strongly encrypted, and so the content in that particular app would not be available once you unlock the phone.
Correct. And so if U.S. manufacturers were to start developing this backdoor key, and they used it, they had it, they made it available to law enforcement under appropriate circumstances, presumably those who were determined to go dark could and would start using an app that would itself not be subject to being opened by that same key.
Yeah, I hate to keep doing this to you. I struggle with that term backdoor key. What I'm talking about is a year ago, the manufacturers of the leading phones in the United States could unlock them if a judge ordered it. I don't know whether that involved a key or their software. Somehow they're able to do that. But you're right. If we return to that world, there could still be, the sophisticated user could still figure out how to use something like TrueCrypt to protect other content on that device. I think there's no way we solve this entire problem, right? Encryption's always going to be available to the sophisticated user. The problem we face post-Snowden is it's moved from being available to the sophisticated bad guy to being the default. And so it's now affecting every criminal investigation that folks engage in. But I agree, there's no way to solve this entire problem. I still think it's worth trying to solve a big chunk of it.
And so the big chunk of it here would involve U.S. manufacturers of U.S. devices, notwithstanding the fact that we still would have the risk associated with apps that couldn't be opened by means of the same methods that you're describing.
Sure, and there's other parts of it that would be difficult to solve too. You mentioned the international aspect of it. Part of the solution, I hope, will involve an international set of norms somehow, because our partners in Europe very much face the same problem we do. And so they're very interested in having the rule of law nations figure out, so what should the rules of the road be with respect to encryption?
Right. Okay, I see my time's expired. I do want to be clear. One of the reasons I asked the question is one thing that I think we ought to be cognizant of is that we ought not put U.S. manufacturers in a position in which they'd be punished relative to other manufacturers, especially if U.S. manufacturers then saw a drop in sales because people, for whatever reason, preferred other products. And we ought to remember the limits on what we can do legislatively. If we were to mandate that legislatively, it wouldn't necessarily fix the problem. I see my time's expired, and I believe Senator Durbin is next in the batting lineup.